third accused person. The matter is for judgment.
Section 296, subsection 2 of the Penal Code. The particulars were that on the 13th day of October 2015, along Nyeri Karatina Road in Nyeri County, jointly with another not before court, the three robbed John Muraguri Gikonyo, a motor vehicle registration number KBZ 144E, a Toyota Harrier, valued at Kenya shillings 2.4 million, and immediately after the time of such robbery, they killed the said John Muraguri Gikonyo. There was an alternative charge of handling stolen property, contrary to section 322, subsection 1 and subsection 2 of the Penal Code. The particulars of the alternative count were that on the 13th day of October 2015, along Thika Superhighway at Ruiru Webbridge in Kiambu County, jointly and otherwise than in the course of stealing the dishonestly retained motor vehicle registration number KBZ 144E, a Toyota Harrier, knowing or having reasons to believe the same to be stolen property. The evidence now, the state called a total of 11 witnesses, and the accused persons gave their evidence. Accused 1 called 2 witnesses, and accused number 3 called 3 witnesses. Accused number 2 gave sworn evidence. PW1 was Faith Njoki, the widow to the deceased George Muraguri Gikonyo. Her evidence was that on the 13th of October 2015, at around 9 p.m., she received a call from a car truck farm. The caller alerted her that her husband's vehicle was heading towards Karatina. Past, the device would send signals. She also tried to call the husband, and when it did not respond, past, the device would send signals. She also tried to call the husband, and when it did not respond, PW2 added that PW1 called him again and told him that the car truck company, and called her telling her that the vehicle was speeding towards Karatina. He called a friend, one Mr. Mogo, who had contacts for Mr. Ndegwa Muhoro, the DCI, then, and sought help. He later learned that the vehicle had been intercepted at Ruiru and the son was not there. He later learned that the deceased body had been traced. He traveled to Nyeri, and he later identified the body when the postmortem was conducted. PW3 was Police Constable Githui Mutioki. His evidence was that on the 13th of October 2015, he was on duty at the Ruiru Webbridge with Corporal Kemboi. He said that his colleagues, Police Constable Musao and one Mutioki from Securex, approached him around 23:00 hours. That PC Musao told him that a motor vehicle registration number KAT 144P was being driven at some abnormal speed towards them. Mudioki from Securex was liaising with the officer on phone, getting updates on the whereabouts of the vehicle. That one lady came and identified the brown jacket, the brown leather jacket, rather than the jacket. Then they called their seniors and handed the exhibits and the suspects over, and he went to clear the road. PW4 was Alphonse Musau, who was part of the contingent. Both witnesses named a certain Mr. Modoki from a security company was present as the examination as exhibit number. PW8 was Dr. Ubiero, who performed the post-mortem on the body of the deceased. He established the probable cause of death of the deceased as asphyxia, secondary to strangulation, and he produced his report for court. PW9 was Evans Kivoi. He was the duty officer among the 3 police officers who mounted the roadblock that intercepted the motor vehicle on the material night. His evidence agreed with that of PW4 and PW5. PW10 was Mark Mwema, who testified under the cover of the protection box. PW11 was Daniel Kieni, whose evidence was not to be and was replaced by PW12, a forensic expert. So PW12 Police Constable Nelly Meli was a forensic officer who produced various cellular phone communications as exhibits in this case. And after the close of the prosecution's case, the court placed each of the accused persons on their respective defenses. And now I get to the defense cases for each accused person. Accused person number 1 stated that he used to work with Nature Cut Stones, owned by Kennedy Dhairo, a company that sells machine cut stones in Daragu, Thika. He said that he spent the 13th of October 2015 between the quarry and the Juja Way Bridge, organizing the passage of some 10,000 pieces of stones that Pastor Justin Muraguri, who testified as defense witness number 1 and ordered, his main role was talking to the officers manning the roadblock so that the lorries could pass. He stated that by 9:30 p.m., the lorry was making its third trip to Kitengera, and they arrived at the Way Bridge at around 10:30 p.m. He alighted from the lorry and rushed ahead so as to talk to the officers on night duty. And as he ran towards the Way Bridge, he heard a voice say, and I quote, "Ndiye huyo anakimbia, piga yeye risasi," to mean that he's the one running, shooting. That he was arrested by armed police officers who ordered him to lie down. He was told to lie down amongst other people, and the arresting officers asked where the owner of the vehicle was, and he said he was behind. That they were taken to Ruiru police station, and at the said station some people were released, and that police officers demanded Kenya shillings 200,000, and when he was unable to raise that amount, he was brought to Nyeri and charged. Accused person number 1 called Justin Muraguri as his witness, who testified that he had purchased stones from the company where the accused person number 1 used to work, that he had joined accused person number 1 at the quarry around 6 p.m. and they left the quarry around 7 to 8 p.m. and they arrived at Ruiru Way Bridge at around 9 p.m. He said he was in his vehicle which was following the lorry in which the accused person number 1 was in. And on arrival at the Way Bridge, they found a heavy jam and later learned that some robbers had been arrested. He was surprised to see accused person number 1 amongst those who had been arrested. Accused person number 1 also called Amiri Kariuki as a witness, who testified that she was a clerk at Nature Company where he worked as a salesman. So I go to accused person number 2, who testified that on the 13th of October 2015, he was living in Juja with his father and working in the father's car wash, which was opposite the Ruiru Way Bridge. And at around 9:30 p.m., they saw a crowd that had gathered at the Way Bridge. He went to see what was going on, and when he was unable to penetrate the crowd, he got into the Way Bridge. And at the Way Bridge, he met one police officer called Mwema, who ordered him to leave, and he slapped him. That he slapped Mwema back, and Mwema dropped his gun, and that PC Musau went to rescue Mwema, and the two arrested him and beat him up. His father said that the OCS of the Way Bridge said that he should be charged for the offense of robbery with violence are a matter of judicial notoriety, so I need not restate them. The offense of stealing is defined. I need not define that. So the motor vehicle registration number KBZ 1440 belonged to the deceased person, that is George Moragodi Gikonyo, and a logbook was produced to prove that. That vehicle was driven from Nyeri until the Ruiru Way Bridge where it was recovered. This movement was not with the owner's consent, so it was definitely stolen. On the use of violence, not only was violence used, but the perpetrators went ahead to strangle and kill the late George Moragodi. This is what in the United States of America is called aggravated robbery. The postmortem report shows the cause of death as physical, secondary to strangulation. This was extreme cruelty and bestial conduct. It goes even beyond definition of violence. According to the state, the perpetrators were more than one, so both alternatives of the second ingredient were proved. The two elements are to be read conjunctively, not disjointedly. And a case is cited, that is Dima Njenge versus Republic, Criminal Appeal number 300 of 2007. And the third ingredient is that of identification. Let me go back and read the ingredients. So the ingredients of the offense of robbery with violence are now a matter of judicial notoriety. And I quote, an offense of robbery is committed when there is stealing, and at the time of stealing, there is use of or threat of or use of actual violence, and when the robbery is committed by more than one person, or when the offender is harmed with any dangerous or offensive weapon or instrument, or immediately before or immediately after uses personal violence or any person on any person, then the offense under section 296 subsection 2 of the penal code is said to have been committed. A case law is cited, that is Joanna Ndungu versus Republic, Criminal Appeal number 116 of 1995. So the next section now proves or addresses each ingredient. And the first one was the ingredient of stealing. And ownership of motor vehicle KBZ 1440 was proved by the production of its logbook that it belonged to the deceased one, John Muraguri. Then on the use of violence, not only was violence used, but the perpetrators went ahead to strangle and kill the late John Muraguri. And the postmortem showed that the cause of death was as physical secondary to strangulation. I think it should be as asphyxia secondary to strangulation. That was extreme cruelty and bestial conduct, which goes even beyond the definition of violence. Then according to the state, the perpetrators were more than one, so both alternatives of the second ingredient were proved. The third ingredient is that of identification. It is true, as submitted, that no one saw any of the accused persons hijack the deceased or even injure him. There was no physical or forensic evidence to tell the court what transpired in Nyeri. All we know is that the vehicle was in Nyeri around Mumbi Estate, and then it is sped off. The other bit of evidence in Nyeri is the recovery of the body of the deceased at Howe Dam. That scene, however, did not shed much light, as all we got were the photographs of the deceased person, which were produced in court as the exhibits number 5A to 5F. Therefore, the only evidence we have against the three accused persons, is the recovery of the motor vehicle registration number KBZ and the evidence of PW3, PW4, and PW9. That is, the three accused persons were found inside this vehicle, with the second accused person being the driver. There is also the controversial evidence by the third accused person. Accused person number 1 and accused person number 2 denied having been in the subject motor vehicle, and each gave a story as to how and why they were arrested at the Juja Bridge. The first accused person said he was arrested while trying to talk to the officers at the Way Bridge to facilitate the movement of his load. A keen look at his defense, however, showed that it was full of holes. DW1 said he had bought 6,000 stones, while accused person number 1 talked of 10,000 pieces of stones. Their timelines also did not tally. The second accused person said he differed with the police constable Mwema and Musau over his entry into the Way Bridge so as to see what was going on, and they fixed him. Now, these two accused persons, that is accused person number 1 and accused person number 2 called for the file in Thika criminal case number 6625 of the year 2015, so as to show that the third accused person was lying to the court when implicating them in this case. This approach, however, turned out to be a Samsonic approach, as they pulled themselves down alongside the third accused person, whom they had hoped to bring down. In Thika, in the criminal case in Thika, that is 6625 of 2015, the first accused person had said this, and I quote, he had been working with Beniva Estate Company as a salesman, and at the end of 2014, his contract with the company ended, and he started working with the clients he had met while working with the company. Then he was arrested on the 13th of October 2015 while on his normal duties. End of the quote. He never mentioned nature cut anywhere. In this file, the first accused person said he had worked with nature cut stones. This is now in the instant case for over 2 years. So DW1 also said that she had worked at nature stone for 1.5 years, and that she had met the first accused person at work. So clearly, they were lying, as it was not over a year past the date the first accused person says he left Beniva Estate Company. The first accused person never mentioned any other employee or the nature cut stones in the Thika matter. As for the second accused person, in the Thika case, his evidence was that he's a driver and he used to operate at the Railway Bridge as a member of the Traders Squad Drivers. His evidence was that he was not in good terms with the police officer named Kemboi, and that around 10 p.m. he met with this Kemboi who wanted to share the money from his driving earnings, that is the second accused person, and that he refused to give him the money, and Kemboi slapped him and they fought. He also said that he was then restrained and arrested over trespass, since they had been directed not to get into the weighbridge. This is all very different from what he said in this case, that he was working at his father's car wash, and that he differed with PC Mwema and PC Musau over trespass. In the instant file, he never mentioned Kemboi or the demand of a share of his driving earnings. So clearly, those two were lying. The court noted that the only person whose story was similar in the two cases, that is the Thika case and the instant case, was that of the third accused person, who testified in both instances that he was employed as a shamba boy. And in the two cases, he said that he had sought leave from his employer and he had sought leave from the employer and the only thing that differed was now the name of the employer. The third accused person placed both accused persons, the third accused person placed both the first and the second accused person in the vehicle all the way from before Karatina up to the Railway Bridge, and that is why both the first and the second accused persons sought to discredit him. The court is aware of the dangers of relying on the evidence of a co-accused, and so the evidence of the third accused person will be handled very cautiously. Apart from the third accused person, we have the word of PW3, PW4, and PW9, who placed the three accused persons in the vehicle, that is number KBZ. PW3, PW4, and PW9 testified that the second accused person was the driver of the subject motor vehicle, and that he, that is the second accused person, was wearing the brown jacket which belonged to the deceased, that is John Chikony. The court was persuaded that these 3 police officers were telling the truth. The allegations of differences between them and the second accused person were proved to be false by their own accused 1 and accused 2. The allegations, I would repeat that, the allegations of differences between them and the second accused person were proved to be false by their own, that is the first accused person and the second accused conduct, when they produced the record from Thika in which they had given different stories. The court commends the 3 gallant officers, that is the police officers, who acted swiftly and intercepted the subject motor vehicle and brought to a sharp end the proverbial 40 days of the culprits. PW3, PW4, and PW9 testified that the second accused person was wearing the jacket with the deceased person's driving license, and the first accused person and the tablets which was suspected to have been used to stupefy the deceased person. The court notes that the third accused person was not found with any incriminating evidence on him, and his defense had a ring of truth. This is despite the fact that the names that he had given of his employer were different. It was not his duty to disapprove this defense. The issue of was plausible. It created some doubt as to his involvement. The court will accordingly give the third accused person the benefit of doubt and acquit him in both the main charge and the alternative charge of robbery with violence, contrary to section 295 as read with section 296 subsection 2 of the Penal Code, and handling stolen property, contrary to section 322 subsection 1 and 2 of the Penal Code. As earlier indicated, the evidence against the first accused person and the second accused person was that of recent possession. The Court of Appeal in 2 cited cases, that is David Mogo Kimunge versus Republic and Isaac Nganga Kahiga versus Republic, the Court of Appeal stated that, and I quote, "It is right that before a court of law can rely on the doctrine of recent possession as a basis for conviction in a criminal case, the possession must be positively proved. In other words, there must be positive proof of, number 1, that the property was found with the suspect, number 2, that the property is positively the property of the complainant, number 3, that the property was stolen from the complainant, and number 4, that the property was recently stolen from the complainant. The proof as to time, as has been stated over and over again, will depend on the easiness with which the stolen property can move from one person to the other." End of the quote. Under the Penal Code, possession is defined as either actual or constructive, and thus, and I quote, "be in possession of or have possession of includes not only having in one's own personal possession, but also knowingly having anything in the actual possession or custody of any other person, or having anything in any place, whether belonging to or occupied by oneself or not, for the use or benefit of oneself or of any other person, and B, if there are 2 or more persons, and any one or more of them with the knowledge and consent of the rest, as or have anything in his or their custody or possession, it shall be deemed and taken to be in the custody and possession of each and all of them." End of the quote. The court is thus satisfied that the second accused person was the driver of the vehicle, hence in possession of the motor vehicle. This vehicle was properly identified by the production of its logbook, and it was stolen from the owner. The second accused person was in the vehicle and was with incriminating evidence, that is the drugs. So all the three ingredients were proven. The duration was barely 2 hours after the vehicle had left Nyeri without any major stopovers, and accordingly, the doctrine of decent possession applied. It is possible to draw a clear nexus between the theft and the recovery. The other elements of robbery with violence were well proven. So in conclusion, accordingly, the first accused person and the second accused person are convicted of the main charge of robbery with violence, contrary to Section 295, as read with Section 296, subsection 2 of the Penal Code. Accordingly, under Section 215 of the Criminal Code, they are convicted. The judgment is signed and dated today by Honorable W. Kagendo, the Chief Magistrate, Court Number 1. The state, anything?
Yes, the state. You're not
So, for this one?
Hamaritwa njitagwo Faith Njoki wa Gakuru, na thiini wa cira uyu ri igoti-ini riri nie ni mutumia wa muthuri ucio woragirwo, na kenjuge ni mahinda maraihu tondu twanjiriirie cira uyu kuma 2015 na ni hindi tutire turaurikia no turathie na mbere, no ni tukoretwo twina so many challenges cia witness makiaga guka hindi ya COVID-19 ikiamba ikihinga maundu, turaigua twina thina muingi na tukoretwo tugiuka guku with my father-in-law since that time. Riu ni turakiuga ni thengiu kuri igoti kana kuri thirikari tondu igoti ni turona ta turathie gukinya muico uria tutakinyite, na ni turahoya justice to prevail tondu ni tukoretwo na mathina maingi tondu ni ndatigeirwo ciana ithatu na hari kamwe kanini ga standard 4 karia gataerewaga ona muthi ugaturakoragia niki kiahanikire na ithe ona ciangianne no ndiratwarana nao ndiari wira tondu ni ngoragwo ndi mundu wa biashara, no Ngai, God is faithful that we had been going on that
financially memuremea vipi?
Financially we are not so much able, otherwise ciana no irakibatara mathomo. Wa mbere ni adropire kwaga gukorwo ari university agicaria wira nigetha tuhote guteithania. The second one ari second year na kau kanini hindi karekire class 8, so igihoya igoti they get the judgment, the prevail the judgment the way it is supposed to be. Yes.
Thank you.
Tagwo Julius iwe kwenye wa ngotho witu ni marumane Laikipia kuria Nyahururu. Riria ndaiguire uhoro ucio wa mwana wakwa arikia kuragwo ndiaraire toro na ngiroka thinacara ni ndakinyite Nyeri na ngigituiria guku ngithinika muno tondu ndiamenyaga kana ni ari thibitari kana ari ha, no eventually ni ndacokire tugikionana na kuri arutagira wira na ngicoka ngithii haria ndoria ni nderirwo aratigirwo handu demu-ini na ngigithii ho demu-ini.
Ni moritũ marĩkũ maya mũkoretwo mũcemanĩtie namo? No ndagũthera ndagĩka moritũ maya mũkoretwo mũcemanĩtie namo kĩmeciria, especially mũno ta
family tarĩu nyina ona tarĩu ngũririkana ngaigua maithori makiuma nyina nĩ aikarire kĩongo nĩ kĩagarũrũkire tindaga tũhingĩte mũrango nĩ ũndũ ndange nĩ athũkire oke thibitarĩ kũrĩa Mathari kumuona nigetha tuthie tukamũige. Nyina nĩ ambĩrĩirie thĩna wa meciria na nĩ athondeketwo mbeca tũgatũmĩra nĩ ũndũ wa meciria make nĩ magarũrũkire. Kĩrĩa twĩkĩte nĩ tũthĩnĩkĩte mũno Uhoro wa mbeca nĩ tũtũmĩrĩte nyingĩ tondũ kuma 2015 to date tũtirĩ hĩndĩ kũrĩ kwagĩa na mention kana kĩ tũkaga gũkorwo tumĩte Nyahururu na mũtumia nake akoima Nairobi. Tũkona thĩna wa ciana gĩthomo-inĩ, ona tigiti ũcio wa gũka nĩ tũtũmĩrĩte mbeca nyingĩ. Koguo no tũrakena cira ũyũ ũngĩthiĩ ũrĩa ũthiĩte, tondũ ona thirikari ngamĩcokeria ngatho nĩ ũrĩa ĩtũteithĩtie. No ithuĩ thĩna ona rĩu meciria tũtirĩ na meciria, na mũno nĩ ũguo ndakwĩra ũhoro wa nyina. Ta rĩu no atindire hau, ona ũngĩmũria ũhoro wa mũriũ ndoĩ, nĩ ariganĩirwo, rĩu atindaga tũmũhingĩrĩte. Koguo twĩna mathĩna ma mũthemba ũcio, na gũkĩmwaga wakira ũkona atĩ nĩ ũndũ mũritũ mũno ũtete mwana na nĩ mũndũ mũraragia nake. Niĩ ona ta rĩu ingĩhĩtũkĩra haha ngĩthiĩ na kĩrĩa ndiendaga kũhĩtũkĩra Nyeri, ona gũtuĩka atĩ no kuo ingĩgerera ngĩthiĩ na gwitũ Mũrang'a. Koguo nyonaga maũndũ macio manditũhĩire mũno. Nĩ ũndũ ndagerera gũkũ nguona ta ndiramuona, ngaigua ũru mũno tondũ nĩ andũngaga akanjĩ tũkaranĩria, rĩngĩ ndamũkora akanjoya na ngari tũgathiĩ na kũrĩa twakiumĩte Mũrang'a. Rĩu kuona Nyeri nyonaga tarĩ thũ yakwa tondũ ndiramuona na ndirona mũndũ ũngĩnyũmĩrĩria. Asante.